Hello. The Divine Code reading for January 11th, pages 435 and 436. We were in the chapter Laws of Intentional and Unintentional Killing and Killing Through Negligence or Under Duress. Topic number 11. What type of killing is considered completely unintentional, and yet the one who killed should go into exile? This occurs if one should have been more careful and taken precautions to avoid the person's death. There are three levels of accidents. So an accident is the person that did this was not intending to kill anyone. The killing was because of an action that he did, and because of the action, something happened and someone died. It was not the person's plan that someone would die from what the person was doing. He's mowing the grass and something horrible happens. That would be considered an accident. The three types of accidents. A, an accident that is nearly intentional, since it was clearly a need for precaution, yet none was exercised. In such a case, it has been explained that the one who killed is judged in court as an intentional murderer, and the blood redeemer clearly has permission to kill him. So the highest level is where there's gross negligence. The person did something that he knew it was dangerous for the public. He wasn't trying to kill anybody, but he was doing something that, he's shooting arrows into the sky where there's people around, and he's just being grossly negligent. And even though he didn't intend to kill anyone, someone dies because of his action that was clearly dangerous to everybody around him. That person would, even though it's an accident, it's unintentional murder, he would be tried in a court of law as a murderer and would be executed for that action. And the blood redeemer would be able to chase him into that situation where he would have to stand before the court. B, an accident that nears unpreventable circumstances, since the perpetrator was unaware that his actions could lead to death. Such a murderer is exempt from the death penalty, and the blood redeemer has no permission to kill him. If he does so, he himself is judged as a murderer. So now we have the other extreme. The second example is from the other extreme, where it's literally an accident that people would not have anticipated. Any rational person would not have expected the action the person did would cause a death. The person is well, they go into examples regarding wood choppers, but the person is doing something that would not have been considered. Any rational person would have considered that to be something to be concerned with. He's following the safety precautions. He's following the OSHA regulations. Everything should have been fine, but the idea is accidents happen. C, an accident in which one should have been more careful and taken precautions to avoid the murder, which then could have been prevented. In this case, the Gerterschaft would be exiled, and if he does not wish to go into exile, the permission for a blood redeemer applies, as was explained in the earlier chapter, chapter 4. Rambam, The Laws of Murderers, chapter 6. So this third category is in between the first. The first category is the the guy was doing something clearly was dangerous and somebody got killed. The second one was the person was following all the reasonable safety rules, and something happened, and therefore he's not considered responsible. The in-between category is the guy was just being sloppy. It was a lesser level of negligence, but he was still negligent. He was not following the OSHA regulations. He was cutting corners when he didn't have the proper safety guidelines in place, and something happened. That would have been a reasonable person, a safe person would have been more careful in this area. That is the in-between category where the person should go into exile. He is not executed for it, but he should go into a form of exile. However, that's understood within the city, within the nation that he's in. If that means that he goes to jail, if it means some kind of penance that he's going through to rectify his negligence, however that's set up within the nation to do that, he needs to do it. And if he doesn't do what he's able to do, then the blood redeemer, the person who can inherit from the dead person, also inherits the responsibility to force the person to seek penance. Now, I would suggest, and this is not really halakha. This is more in the area of musar, that a person that an accident happens through his action, something that he could not have anticipated. It's what we call a freak accident. But he had his action caused another person's death, should cause the person reflection also. Maybe not a required exile, but some form of self-reflection should occur even to that person. It's the time that he needs to take his takum seriously and reflect on what happened. If it happened through his hand, everything is from divine providence. If it happened through his hand, that's something that would need to be taken. The person still needs to take it seriously, but he's not required, and the blood redeemer does not force him into it. The blood redeemer would not be allowed to go after that guy. If the blood redeemer did go after that guy, the blood redeemer would be held liable for anything that he does. Whereas the in-between category, the blood redeemer would not be liable for something that he does, enforcing the person to the area of penance. But that doesn't mean the person that was fully an accident, an unavoidable accident, should just shrug it off and walk on like nothing happened. He should also take it seriously. But that's his individual musar, his individual character refinement. It's not a halakhic requirement for him to do that. Topic number 12. The following example is given in the Torah, Deuteronomy 19:5. If someone was cutting wood in a forest and didn't look to see if someone was nearby, and when he brought the axe down to strike the wood, specifically with a downward motion, and it need not hit the wood, the accident occurs in this way, the wood chopper should go into exile. The metal blade slipped from the handle, or the axe slipped from the hand, or it knocked out a wood chip that fell below the level where the wood chopper was standing. See free on Deuteronomy 19:5. And a person who was passing by was hit and killed, then the wood chopper is considered an accidental murderer. This is because people are not usually found in the forest, and therefore his lack of caution is not out of negligence. for which the person would be liable. Nevertheless, since others are permitted to be there, the caution would have prevented a lethal accident, and it is not considered unpreventable. This is based on the exclamation of Deuteronomy 19:5, according to the sages in the Mishnah of Tractate Malkut 7b. This is also the opinion of Rambam, Laws of Murderers 9:15. So, if the person is a woodchopper, he's in the forest, he's in a public area, other people would be allowed to be around him, but it's not expected, but they could be. He needs to look around, and he needs a certain level of precaution. There needs to be what we would call OSHA. In America, we call it OSHA regulations. There needs to be safety protocol that he follows to make sure that the area is safe. And it would be a good thing for the courts of law to establish a list of what he needs to do in order to assure that he knows what he needs to do. Because otherwise, people don't think these things through as well as they should. So it's important to give the person needs a list of things that he needs to do in this situation in order to be careful. He needs to look around, maybe put caution tape or something in the area that would let people know to be careful, not to go around where he's working. We have the situation if you're mowing grass, and it's a possibility that the grass mower could pick up a rock, a stone, and fling it. It's going to fling it a certain number of feet. So we need to be careful that we're not mowing grass where people are within that distance that it could be a threat to them. That would be an example of how the wood chopper needs to be careful to know that there's nobody, to be extra aware that there needs to be nobody within a certain number of feet or within a certain distance to where he's doing his work. So if he is careful and an accident happens, then it would be if he followed the rules, whatever the court says he has to do, and something happens, then he would not be liable. It would be a unpreventable murder. If he is doing it in the forest, but he doesn't bother to check because he figures, who's going to be out here in the forest? But somebody's walking through the forest, and something happens to that person, then that would be the mild negligence category. And if the person is doing his work in a public street, he's on the sidewalk chopping wood, and there's people passing by all over the place. If something happens there, that would be considered the gross negligence, and he would be liable for murder in a court of law. This is comparable to the law of one who sticks his head into the path of a dropped stone, as explained in Mishnah on Malkut 8a. In this case, the wood chopper is exempt from exile. In any situation for which a Jew was exempt from going into exile because of the lethal accident was unpreventable, a ger teshav would also be exempt, as implied in Malkut 9a, and by Meiri's exclamation there, regarding one who killed accidentally by the upward motion of the axe or by the chip flying upward. So the person follows the protocols. The upward motion of the axe, I mean, we assume that he's put, he's also checked behind to make sure that he's put some kind of a what we call caution tape, or something that the people should not be walking behind him. And if someone does walk behind him, it would be like someone who, someone throws a stone and then suddenly someone shows up unexpectedly, even after he's um, checked and put up caution. He's put up barriers so people shouldn't be there. If they show up there, that would be a certain amount of responsibility would be on the person that the victim of the accident, and the person would not be liable. So the upward motion assumes that he did check behind him. When the Talmud is in the Bible is talking about the upward motion, it assumes that the person did check before he did the upward motion. But in a certain sense, it's out of his control at that point. If the blade got stuck in the wood and then fell out, and then the axe fell down, not during the action of the wood chopping, bringing down the axe to cut the wood, and it killed a person who was below. This is the Rambam's in the Laws of Murder 6:15 interpretation of the Mishnah in Malkut 7b that states if the metal blade slips out from the wood being cut, meaning that the axe got stuck in the wood, and when the cutter loosened his grip, it fell and killed someone, as interpreted by Malbin in Deuteronomy 19:5. This is considered as being unpreventable because it did not happen during the descending chop with the axe. So it's not the case where the person is being negligent. I guess it's understood that axes can get caught in wood, and that's not a normal thing, and it's not something that, when that happens, there's certain things that even if a person follows all the safety protocols, there are certain things that can happen during the action, whatever he's doing. In this case, we're talking about chopping a wood, but the same principles would apply elsewhere. Once the person follows all the safety protocols and something outside of his control happens, he's not considered liable for that. And it would be considered a complete accident. It's unfortunate, but it would be considered an accident, and the person does not go into exile, and the blood redeemer does not have permission to chase him. Or if a chip of wood fell out from the chopping. Rashi's explanation on Tractate 7b, according to the opinion of the sages, it is clear that Rambam as well holds this as unpreventable. So we could, apparently the wood chip coming out from the wood is, we could argue that the person needs to, while he's putting up his barriers, he's marking out the area that he's working so nobody should come into it, that just like he doesn't want people getting so close that they could be hit by the axe, he should also make sure that people are not close enough that they can be hit by a wood chip. And normally a wood chip would be less lethal than an axe. So whether it's, but still, you should still have a certain distance marked. This would be in a case where, even though he did the proper caution, something happened that this would be like a freak accident. First of all, for a person to get hurt by a wood chip would be a freak thing. A person to get killed by a wood chip would definitely be a freak thing. Even a wood chip that's dislodged from an axe is not going to be, it shouldn't be dangerous. So we're talking about a freak occurrence that would not have been expected. And if that happens and a nearby person who wasn't below the chopping area. So we're talking about a wood chip that flew an unusual distance. It wasn't within I mean, the guy's just chopping wood, and all of a sudden he somehow the wood chip, a big enough wood chip goes far enough that it's not normal, and then it actually would hit somebody and kill somebody, is so outside of anything that could be reasonably expected that the wood chopper would not be considered responsible for that. So the person who wasn't below the chopping area and was struck and killed, these are considered unpreventable whether or not the wood chopper took precautions. So even if the wood chopper took precautions, but the person's far enough away that the precautions would not have prevented that from happening. This is an accident that's outside, it's far enough away. If the person did not take precautions and the accident happens, but the accident is outside of what would have been prevented by the precautions anyway, therefore it wouldn't make a difference, and that he would not be held responsible for the accident just because he didn't take precautions. Um, it because the whether or not he took precautions is not relevant to the actual case that would be before a court. When a case goes before a court, it's not a time to think theoreticals. It's only a time to look at what actually happened. You can talk theoreticals the rest of the day, but in a court case, only the facts matter. The wood chopper is completely exempt. The reason is because this occurrence is unusual and could not have been foreseen. So there's a certain threshold where we say, the OSHA regulations can only go so far. Safety protocols have to deal with reasonable concerns, not unreasonable. Unfortunately, in today's society, American society, with litigation, safety often has nothing whatsoever to do. Safety laws have nothing whatsoever to do with what's reasonable. It's just that somebody sued somebody over something, and therefore everybody makes a safety law. And things that probably should be looked at are not taken seriously, and things that are silly are taken seriously, and we get to be a mess. Therefore, a court of law, a no-hide government needs to look at real concerns and make safety rules that apply to reasonable considerations. Thank you.